Welcome to Close to Home with Nicole Sullivan.
Hi, everybody. Welcome to Close to Home with Nicole Sullivan. I'm Matt Skye. Nicole, a lifelong Mississippi Gulf Coast resident and experienced attorney, shares her legal insights on everything from real estate to estate planning, bringing clarity to a complex field. Nicole, thanks for joining.
Thanks for having me. Nice to be back.
So let's jump into tenancy types. Could you clarify the typical distinction between joint tenancy and tenancy in common regarding property ownership?
Sure. So here in Mississippi, we have multiple tenancy types, but the most typical are going to be your joint tenancy and tenancy in common. So tenancy in common is the default here in Mississippi. So if someone takes title, my husband and I, Nicole and Charlie, the default is going to be to tenancy in common if there's no other language. And what that means is if I pass away, my 50% interest in that property has to be probated, or it goes to my heirs via my will or intestate succession. Intestate succession is when you do not have a will, but it's basically 50-50 ownership. My 50% is always going to go down my lineage, and then my husband's 50% is going to go down his lineage. A lot of times this is the way that people take title if they are not married. Say you're owning property with a sibling or a friend, whatever it may be. Typically, that's how title is taken, as tenancy in common. The other option we have is joint tenancy, and that's with the right of survivorship. So same example, my husband and I own a property as joint tenants with the right of survivorship. If I pass away, my ownership interest goes fully to him and vice versa. If he passes away, it all goes to me. And that's without the need for any type of probate. So those are going to be the two most typical types of tenancy in Mississippi on what we see, especially when we're doing a closing for people. I like to explain the deed, what it means, especially as it relates to probate once someone passes away, one of those tenants.
So what are the main pros and cons of joint tenancy?
Joint tenancy is great for married couples especially, and again, to avoid probate when the first of those tenants passes away. So again, same example, Nicole and Charlie as joint tenants with the right of survivorship and not as tenants in common. That's the statutory language that's required here in Mississippi for joint tenancy. It's great because let's say my husband passes away in an accident, the property is automatically going to go to me. There's no need for probate. I don't have to get the court involved. It's an automatic transfer. It's kind of like having a joint owner on a bank account. Then once both people have passed away, that's when probate would be required unless we have a different titling situation. A lot of times suggest a deed reserving life estate, but we won't get into that right now. So to me, the pro is there's no need for probate with a marital couple. It automatically passes to the survivor.
So I think we touched on this a little bit as well, but can we do the pros and cons of tenancy in common as well?
Yeah. So to me, there are more pros to joint tenancy than there are to tenancy in common. But tenancy in common is a great thing for, again, if you're wanting your 50% interest or your third interest or your 25% interest, whatever that may be, to pass down to through your lineage. So if you have tenancy in common, you can own property in different percentages, whereas when you have joint tenancy with the right of survivorship, you just own undivided interest in it, and all of your interest is passing to the survivors. When you have tenancy in common, you could have 4 owners where they're not all owning 25% each. The percentages can be spelled out differently. So that, I would say, that's a pro. Again, if you're owning property with friends, business partners, siblings, those type things, I think that's a great avenue to go. However, probate would be required in that instance when any one or all of the tenants pass away.
So how does the choice of tenancy, joint or common, affect property distribution without a will?
If you do not have a will here in Mississippi, the property is going to pass through what's called intestate succession. There are different options available when you pass away and say you have a spouse and children. Then your interest in that property is going to flow through to them. If you don't have a spouse or children, then it goes to your parents and siblings. There's this lineage, basically, if you pass away without a will, where your interest in that property is going to go. If you pass away with a will, there is this misconception that probate is avoided in that situation. And that's not the case. Here in Mississippi, if you pass away with or without a will, probate is required unless we title the property appropriately. A lot of times people think the only way around probate is to have a trust, and that's not the case either. We have different ways around it, and that's why I say I want to be your friend and also your attorney and give you these different options. A trust could be a great option, but typically we can do other things to get you around probate as it relates to how you title your property. I mentioned a little earlier a deed reserving life estate. That's a great option. We also have a transfer on death deed here in Mississippi. That could be a great option based on the situation and what you're wanting to happen after you pass away. But ultimately, I think the theme for this question and answer is the difference between having a will versus not having a will and what's required when people pass away. Whether you have a will or don't have a will, probate's going to be required unless we do something else to the title to get you around probate.
So to clarify, having a will, does it ever override the default rules of a tenancy?
It does not. So here in Mississippi, title controls. So you could have a deed that has that the property is going to pass to your daughter, Suzanne, when you pass away. But then you may have a will that says the property is supposed to pass to your son, Bradley, when you pass away. The deed is going to be the document that that controls. So while you may have a will that says something otherwise, it's technically irrelevant or void as it relates to this deed transfer because the deed and the title is going to control, not the will.
What advice would you give homeowners unsure of which tenancy type to choose or whether to create a will?
I always suggest having a will as an insurance policy. So even if we're able to create tenancy that will avoid probate, I like for people to have a will as an insurance policy. The reason for that is they may inherit property that they don't realize either right before their death, after their death, and there may be a time that we have to probate their will. The goal when I meet with people when we have estate planning consults is to get them, or you should say their children, around probate once they pass away. And again, the best avenue for that is having a deed reserving life estate or a transfer on death deed or a trust based on the situation. I go through and talk through people and again, what do they want when they pass away? And if we can go through these different conversations, each person is different. So I'm going to have the attorney answer of it depends. It depends on their situation and what they want. But we can make a way to do it through tenancy on their deed. But I always suggest having a will as, again, I call it an insurance policy to make sure that if there's any property that they may have forgotten about. Some people may own a lot in North Mississippi that they inherited from a grandparent a long time ago, and they just pay the taxes every year because it's $50 and it's not top of mind when they're having an estate planning consult with me. And I don't know to look for that because they haven't talked to me about it. And then say 20 years later, their child comes and says, hey, I need to sell this piece of property. What do we do now? That's when the will comes into play and when we really need to have that will, even though we've gotten around probate with the assets that they knew about or more aware about when they passed away. So again, think of a will as an insurance policy. I want you to have it, even if we have everything else, all our ducks in a row otherwise.
Is there ever a case where someone doesn't need a will, or do you almost always recommend it?
I like to suggest having a will even if we title everything appropriately for people that have minor children. The reason for that is we can create what's called a testamentary trust, which indicates who's going to be the trustee or the person in charge of the money for the children once they pass away. We need to name somebody for that. And we also need to name the guardian if they were to pass away while their children are still minors. Here in Mississippi, children are minors until age 21, which is a little atypical. Most other states are around 18. So here in Mississippi, children are taken care of from a legal perspective as a minor until they're age 21. So I want to make sure that people that have minor children, we outline who's going to be the trustee and guardian for their children, even if we have everything else titled appropriately. And I think that's important because you want your family members, the court, whoever it may be, to know who you want to take care of your children. And you've already made that decision for them, whether or not the will has to be probated or not.
You sort of mentioned the will being almost an insurance policy of sorts. What are some of the key ingredients that should be included? Not ignored, I guess.
Right. So the most important things that I like to see and put in a will are, most people think you have to name all of your assets and put that in a will. You don't have to do that. So when I meet with people and make suggestions on how to avoid probate, it's okay, you have all these different financial accounts, whether it's checking account, savings account, retirement, life insurance. Make sure you have beneficiaries on all of those accounts. If you don't have beneficiaries on those accounts, that would be a reason we would have to probate your will. But we can get around probate as it relates to financial assets if you just list beneficiaries on those accounts. List beneficiaries, it could be your spouse, your contingent beneficiary could be your children, whatever it may be, make sure all of those things are in line. Then we move on to, do you have any specific bequests? So we want to make sure specific bequests are gifts. Do you have any specific gifts? It could be a gun collection. It could be your jewelry. It could be a specific home. Any of those things. I like to list out your specific bequest. I also like to list out who you want to name as your executor. We have your executor named. Your executor is the person that's in charge of the business affairs of your estate once you've passed away. I also like to name an alternate. It's super important to name an alternate because most times people are naming their spouse as the executor. We don't typically have to probate an estate when the first of the spouses pass away, and usually they're naming each other as the executor. So usually when we're probating wills is when the second spouse passes away, and typically the alternate is who is actually acting as the executor. At least that's what I've seen. So we like to have the executor listed, the alternate executor. We go through any specific bequests like I talked about. It's also important to go through what we call the residuary estate. Anything that's left over that you didn't specifically title, that you didn't specifically name as a specific bequest, you say everything that's left over goes to this person, these 4 people, whatever it may be. We want to make sure that we handle that residuary or the residue, the rest of your estate. What are we going to do with that? Those I would say are the most important points to me: executor, specific bequest, and residuary. There are other things involved, but if we're talking a simple will, those are the things that I want to make sure that we hit on in every consult.
And those are, for those who don't know, what is that term, residuary?
Residuary, like I said, is the rest, the residue, anything that's left over. That's what a residuary clause would be. Anything that's left over, who do we want that to go to?
So as we jump into legal precautions, are there any particular legal precautions or considerations that homeowners should consider when deciding on a tenancy type and general estate planning?
I like to say, my attorney answer is it depends. I sit down at closings with people and for example, today I sat down in a closing and it was a husband and wife. The title was only going to go into the husband's name. Once I talked through what that meant for them after, say, he passed away, if he passed away with the property only in his name and not with them as joint tenants with the right of survivorship, the property is not automatically just going to go to his spouse. The property, if he passed away holding title in just his name, would go to his spouse. And in this case, he had 3 children. So it would be split 4 ways between his spouse and 4 children. When I talked through that with him, he said, oh no, I want it to be easy when I pass away for her to just get the home. So then we go through the situation of, okay, do we want to do tenancy in common or joint tenants with the right of survivorship? In that case, they chose joint tenants with the right of survivorship because, again, the goal was to make it as easy as possible when the first of them passes away. So to me, the precautions are, what are you wanting when you pass away? What are we trying to avoid? Are we trying to avoid probate? Do we want it to go to your children and spouse? It's a situation that just depends on the client, and I like to talk through those again as their friend and as their attorney. Here's what to expect. Here's how we avoid that, or here's how we can make certain things happen. It's a personal preference for them, and I like to go through those options with them.
As the friend attorney.
Yes, friend attorney. That's I would say my theme. That's what I like to be. I'm your friend. I'm your friend and your attorney.
So what are some of the common misconceptions people have about property ownership and how tenancy types work? I'm sure you see a lot.
I think I would say there are 2 that I see the most often. I've already hit on this once. When someone passes away with a will, there's a misconception that if mama and daddy left me the property, then I automatically get the property. I don't have to go through probate. There's a will saying I get it. That's not the case. if you think about it, it makes the most sense when there is a will to have to probate it, to make sure that this is a valid will, to make sure it meets all the statutory requirements, to make sure that is in fact your parent that signed that will. Make sure they were in their right mind when they signed that will. There's a lot of things to consider. So it's important when a will is created that we have to probate it, again, if they haven't titled things appropriately so that it passes outside of probate. So if we have to probate that will, that insurance policy, then yes, we have to probate the will. I think that's the biggest misconception when someone has a will. They say, Mama and Daddy have passed away. It's going to Suzanne. Suzanne brings their realtor a will saying, see, I own the property. They don't. We still need to go through a process in order to get that property into their name. The other misconception I see a lot, actually I'll add two more. The other misconception is that we cannot sell property while an estate is pending. So we can still open an estate and sell the property while probate is pending. A lot of people think you have to go through the entire process and close out the estate before we sell the property. That's not the case. We can sell it while the estate is still pending. We just have to get a court order authorizing that sale. So that's a misconception that we have. And the last one that I see is people have this misconception that whomever is named as the executor can just change any part of the will that they like to fit their own agenda. That's not the case. It may seem that way sometimes, but they can't change the will and what's included in that, and they can't just do what they'd like. Everything has to be court approved. So that to me is a big misconception that they can just do what they want. No, the executor is still held accountable. It's a fiduciary position. Everything has to be done to the benefit of the estate, meaning whoever died, the decedent, their wishes. They have to do those duties. They sign an oath that's notarized, stating that they're going to do everything in the best interest of the estate. So that is a big misconception as well, as the administrator, the executor can just change what they want. Not true.
So the executor really just enforces the will, right? There's no additional power beyond that, if I'm correct.
Right. They're just the person that's authorized to distribute assets pursuant to the will, but also with court authority. So again, they can sell property while the estate's still pending, but the court has to approve that contract to sell the property. The reason for that is to make sure that the executor or the administrator is selling the property at fair market value. It's got to be a deal outside of the family, or if it is within the family, it's got to be for fair market. Everyone has to agree to it. Joinders have to be signed. A joinder is something saying, yes, this is the contract. This is how much we're selling it for. I agree that we should sell it for that amount to that person. So a lot of things, there's a lot of red tape to get through. And like you said, they don't just get to do with it what they want. They have to enforce the will, what it says, the wishes of the decedent or the testator, to make sure that everything is being followed pursuant to the decedent's wishes.
So as we wrap up, Nicole, we've covered a lot of ground here. Are there any major takeaways you would hope our listeners and viewers would have from today?
I think the major takeaway that I would bring to you guys is when you go to a closing, and whether the closing is with myself or another title company or another attorney, make sure that you have that deed explained to you when you're the buyer. Make sure that the tenancy that's listed on the deed isn't just some blanket language that the attorney or the closer has chosen for you. Make sure you have an understanding of what that means for you and what that means once you pass away. It's so important to understand those things. So just make sure that you get a good explanation of the tenancy that you're taking and how it's going to affect you, and talk through those different options, because what they have listed may not be the right thing for you, or you may have different wishes. So I would say that that's my big takeaway from today's filming. It's
a great point to wrap up on. Everybody, thank you so much for tuning in to Close to Home with Nicole Sullivan. For more information or to connect with Nicole, visit sullivanlawfirmplc.com. Also find her on social media. Nicole, thanks for joining.
Thank you. Appreciate it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.